On behalf of the Law Society, I wish to welcome all of you to session number 2. I've been asked by Mr. George Collins Williams to advise you again with respect to the papers. I told you last week that you're going to be getting some very excellent material, and you will. We are desperately trying to get them all together, or at least have all the papers in, by the end of the last lecture in this series, which is the end of November. The idea being that once all the papers are in, they will be packaged up into a nice, neat book, and you will all be receiving the papers in the mail, hopefully before the new year. You must bear in mind, and I hope you will, that there's a substantial amount of photocopying to be done, not only in connection with these papers, but obviously in connection with the bar admission course. But certainly the people here are going to do their very best to try and have the papers to you in December. Now, if we can move right along, our first speaker tonight is His Honor Judge Anthony Vannini. Honor Judge Vannini was born in Sault Ste. Marie. He obtained his Bachelor of Arts degree cum laude from the University of Toronto. In 1940, he was called to the bar in 1943 and became a Queen's Counsel in 1955. And he practiced in Sault Ste. Marie in the fields of civil litigation and criminal law until 1966, when he was appointed to the County Court bench. Since 1975, he has delivered papers at seminars sponsored by the Canadian Judicial Council for the county and district court judges. Some of the papers are the conduct of a civil trial, conduct of a criminal trial, and conduct of a criminal jury trial. For those of you who on occasion have the opportunity to look at the odd volume of the CCCs or the CRs, you will realize that His Honor Judge Vannini is a superb judicial mind. He is a prolific writer, and there is hardly a volume that goes by without one or two cases of His Honor Judge Vannini being reported. Without further ado, His Honor Judge Vannini.
Ladies and gentlemen, against the background of the duty and the powers of the police, the right of the individual to remain silent, the right of the individual to the protection of his person and of his property, and against the background of the freedom of the press, I propose to review some of the recent decisions on willful obstruction of and assaults on the police in the execution of their duty, on public mischief, and on obstruction of justice. Included in my paper, which you will be receiving, and by way of background material as well, is a paper I prepared in 1972 entitled, "May a Suspected Offender Lie with Impunity?" The paper concludes with the admonition, "Lie not about your guilt, lest ye also be found guilty of lying." We shall see if this be so in the light of the authorities since then. In my paper, I also deal with certain of the offenses against the administration of justice, more particularly perjury, witnesses giving contradictory evidence, and false affidavits. The paper contains the citations of the cases to which I shall be referring, and an addendum which you will be receiving with the paper contains a list of additional authorities with their citations as well. The duties, the powers, and the limits to the powers of the police were recently restated by our Court of Appeal in the Deadman case, where the court observed, the primary functions of the police at common law are to prevent crime, to protect life and property, and to detect and apprehend offenders. The latter function involves the gathering of evidence not only to warrant laying a charge against a specific individual, but to establish his guilt, if he be guilty, in a court of law. In carrying out their general duties, the police have limited powers, and they are entitled to interfere with the liberty and property of the citizen only where such interference is authorized by law. It is, of course, a constitutional principle that the citizen has a right not to be subjected to imprisonment, arrest, or physical restraint that is not justified by law. And every invasion of the property of the citizen is a trespass unless legally justified. On the other hand, when a police officer is trying to discover whether or by whom an offense has been committed, he is entitled to question any person, whether suspected or not, from whom he thinks useful information may be obtained. Although a police officer is entitled to question any person in order to obtain information with respect to a suspected offense, he has no lawful power to compel the person questioned to answer. Moreover, a police officer has no right to detain a person for questioning or for further investigation. No one is entitled to impose any physical restraint upon the citizen except as authorized by law. And this principle applies as much to police officers as to anyone else. Although a police officer may approach a person on the street and ask him questions, if the person refuses to answer, the police officer must allow him to proceed on his way, unless, of course, the officer arrests him on a specific charge or arrests him pursuant to Section 450 of the Code, where the officer has reasonable and probable grounds to believe that he is about to commit an indictable offense. Earlier, in the Collette case, the Supreme Court of Canada reaffirmed the right of a citizen to the control and enjoyment of his own property, including the right to determine who shall and who shall not be permitted to invade it. Of this, the court observed, this appeal raises the all-important question of whether the property rights of the individual can be invaded otherwise than with specific statutory authority. It is true that the appellant's place of residence was nothing more than a shack or shelter, which no doubt was considered inappropriate by the city of Prince Rupert. But what is involved here is the long-standing right of a citizen of this country to the control and enjoyment of his own property, including the right to determine who shall and shall not be permitted to invade it. and it reaffirmed the common law principle which had been firmly engrafted in our law since Seamayne's case in 1604, that the house of everyone is to him as his castle and fortress, as well for his defense against injury and violence as for his repose. In England, again, in the Coffin case, the court held that in the exercise of a police officer's duty to be a keeper of the peace and to take all necessary steps with that in view, it is within the power of the police to assist a person in charge of a disco to eject the non-invited, and within their power, when these persons were on the street, to ask them to move on, and in doing so, that they were plainly acting in the execution of their duty being to keep the peace. The Lindley case in England had to do with the right of the police to search a person in custody and to remove parts of their clothing. Of this, the court said, police constables of all ranks derive their authority from the law and only from the law. If they exceed that authority, however slightly, technically they cease to be acting in the execution of their duty and have no more rights than any other citizen. This is a most salutary principle upon which all our liberties depend, and it is not to be eroded merely because, as in this case, the limits of the constable's authority may not have been clearly defined, and that the constable in question was acting in the bona fide belief that she was authorized to act as she did. These considerations may well provide an answer to criticism of the officer concerned. They do not deprive the aggrieved citizen of any of her rights. And the court poses the question, what then are the limits of the authority of a constable to search a person who is in custody and to remove parts of their clothing for their own safety? Then, dealing with the general principles, it went on to say, it is the duty of the courts to be ever zealous to protect the personal freedom, privacy, and dignity of all who live in these islands. Any claim to be entitled to take action which infringes these rights is to be examined with very great care. But such rights are not absolute. They have to be weighed against the rights and duties of police officers acting on behalf of society as a whole. It is the duty of any constable who lawfully has a prisoner in his charge to take all reasonable measures to ensure that the prisoner does not escape or assist others to do so, does not injure himself or others, does not destroy or dispose of evidence, and does not commit further crime, such, for example, as malicious damage to property. This list is not exhaustive, but it is sufficient for present purposes. What measures are reasonable in the discharge of this duty will depend upon the likelihood that the particular prisoner will do any of these things unless prevented. That, in turn, will involve the constable in considering the known or apparent disposition, and sobriety of the prisoner. What can never be justified is the adoption of any particular measures without regard to all the circumstances of the particular case. And here's the crunch of that decision. The police had arrested a somewhat inebriated and disorderly lady of the street. And at the police station, among other things, they insisted on removing her brassiere. She resisted this, and in doing so, committed an assault against the police lady constable. She was convicted, but on the appeal, the conviction was quashed. The forceful removal of her brassiere, that's how I pronounce it, was understandably regarded by Miss Lindley as peculiarly offensive. Such conduct would require considerable justification. It was inherently unlikely that possession of the brassiere could lead to accidental injury. If it was to be used intentionally for this purpose, other clothing would probably have served as well. Indeed, there would have had to have been some evidence that young female drunks in general were liable to injure themselves with their brassieres, or that Miss Lindley had shown a peculiar disposition to do so. It would obviously be a justification if Miss Lindley had by words or conduct threatened to do so, but that is not this case. I have branded the case as that of the yanked brassiere. In Regina and Rothman, Mr. Justice Lammer distinguished between the right to remain silent and the privilege against self-incrimination in these words. In Canada, the right of a suspect not to say anything to the police is not the result of a right of no self-incrimination, but is merely the exercise by him of the general right enjoyed in this country by anyone to do whatever one pleases, saying what one pleases, or choosing not to say certain things, unless obliged to do otherwise by law. It is because no law says that a suspect, save in certain circumstances, must say anything to the police that we say that he has the right to remain silent, which is a positive way of explaining that there is, on his part, no legal obligation to do otherwise. His right to silence here rests on the same principle as his right to free speech, but not on a right to no self-crimination. Therefore, any frustration of his choice not to say anything is not an encroachment to a right of no self-crimination, for he has such a right only qua witness and qua accused. Because Section 450, subsection 2D1 of the Code empowers a police officer to arrest a person without warrant for the purpose of establishing the identity of a person who falls within subsection 1 thereof, it now constitutes an obstruction of the officer in the lawful execution of his duty, contrary to Section 118 of the Code, for such a person to refuse to give his name when requested by the officer so that he might proceed to lay an information or issue a ticket for an infraction under the Motor Vehicle Act of British Columbia. That's the Moore case, which I have styled the bicycle case. Mr. Justice Spence went on to distinguish the facts of the case then before the court with the facts in the case in Rice versus Conley. And then, apparently because of some qualm of conscience, he thought he should add this. I add that in coming to this conclusion, I have not forgotten the provisions of the Canadian Bill of Rights, nor the topic of individual freedom generally, but I am of the opinion that there is not even minimal interference with any freedom of a citizen who is seen committing an infraction by a police constable in the police constable simply requesting his name and address without any attempt to obtain from that person any admission of fault or any document whatsoever. On the other hand, the refusal of a citizen to identify himself under such circumstances causes a major inconvenience and obstruction to the police in carrying out their proper duties. So that if anyone were engaged in any balancing of interest, and that of course has to concern the court, there could be no doubt that the conclusion to which I have come would be that supported by the overwhelming public interest. Then following the Moore case, His Honor Judge Carson held that a charge of obstructing police contrary to Section 118A is made out where an accused who is found committing a breach of a municipal bylaw refuses to identify himself. Where an accused walks away from a police officer after being told that he was under arrest for suspicion of assault, and then scuffles with the officer when the officer reached out to apprehend him, the officer was found to be acting in the lawful execution of his duty, and the acts of the accused constituted obstruction. Once the accused started to leave the scene without the officer having had an opportunity to establish his identity, the officer had the power to arrest him under Section 450, subsection 2, for the purpose of establishing his identity. Although an accused is entitled to remain silent in response to the questions of an officer by simply saying that he has nothing to say, which silence would have constituted no offense at all, the right to remain silent did not confer a right upon the accused to mislead the officer. Although he is entitled to remain silent, he is not entitled to deny his guilt. And once he chose to offer the information, it was required that he be truthful or risk a charge of obstructing the police officer in the execution of his duty. I query that. Hence, it constitutes obstruction for a motorist who was involved in a car accident when questioned by the investigating officer to say that he knew nothing about the matter. That is a decision of His Honor Judge Langdon. That decision seems to be, now mind you, I obtained that from the Weekly Criminal Bulletin, and it may not be an accurate representation of the decision in the case. But if it is, the decision appears to be contrary to the observations of Mr. Justice Martin in Regina versus Spezzano, where he observed, I do not wish to be taken as holding that all false statements to the police during the investigation of a crime made by made by a suspect in order to circumvent a prosecution of himself are capable of supporting a charge of willfully attempting to obstruct, pervert, or defeat the course of justice. Clearly, a false denial of guilt would not constitute the offense. To hold otherwise would be indirectly to require the suspected person to admit that he was guilty and nullify the great principle of the common law that an accused has the right to remain silent. Well, how does an accused stay within the law? Does he have to use the words, "I'm not guilty"? But if he uses the words, "I didn't do it," would that lead him foul of the law? Then, in my paper, I deal with Section 118 in greater detail, setting out the essential ingredients of the offense. But of interest is the decision of His Honor Judge Upper, is it? Oper? In Regina versus Alaimo, to the effect that Section 118A creates two separate and distinct offenses, that is, of resisting and of willfully obstructing, that at the very least there must be some direct confrontation implied in the word resist, and that there should be at least some small degree of force. And further, to resist requires some degree of force to prevent the officer from exercising his duty and conduct beyond mere passive resistance. That's the case that comes out of Sault Ste. Marie of Regina versus Stertini, and a decision of His Honor Judge Greco, where the accused, the police, in attempting to arrest the accused went limp. And nothing else did they do, as a result of which they had to carry him out and into the van. And His Honor held that that did not constitute a resistance of the officers. I'd like to skip over and deal with the request by a police officer of a motorist to produce his license. The refusal to hand over one's driver's license pursuant to a demand that he produce it, as required by Section 19 of the Motor Vehicle Act of British Columbia, constitutes an obstruction of the police officer. The request to produce one's license is not met where the driver merely holds it in view of the officer but refuses to hand it over. In an earlier decision, subsequent decision. No, I go back again. It's an earlier decision of mine. Merely waiving the license at the officer, and in such a manner that he could not read it, is not producing the license, and does not constitute a compliance to produce the license pursuant to Section 14.1 of the Highway Traffic Act. And I found on an appeal to me that he was properly convicted of obstructing a police officer. An attempt to divert suspicion from oneself by lying constitutes an attempt to obstruct a police officer in the execution of his duty. Recently, In the Quist case, a decision of the Saskatchewan Court of Appeal which allowed a Crown appeal from the accused's acquittal on a charge of obstructing a peace officer in the execution of his duty. The facts were these. The accused had been stopped by a police officer and prior to a breathalyzer demand being made to him, ran away. Although the accused was not under arrest and not subject to any legal obligation to answer questions pertaining to the amount he had to drink, Section 235, which authorizes a police officer to make a breathalyzer demand, imposes a duty upon a driver to remain in the presence of the police officer until he has completed the duties imposed upon him by that section. Further, the obligation to remain with the police officer arose prior to the making of the actual breathalyzer demand, as were it to arise only after the demand had been made. The enforcement of Section 235 would be completely frustrated by an accused simply being able to drive or run away. Further, there is no obligation upon the police officer to inform the accused of the legal justification for interfering with his rights of access. That case should be contrasted with a recent decision in England in Clouser versus Chaplin. There, the defendant who was involved in a collision left the scene. And an hour later, police officers came to his home asking to speak to him. His wife told them that they must wait outside the door, which she then shut. When the defendant appeared, acknowledging that he was the driver, he twice refused requests to provide a sample of breath and started to retire into the house. One of the constables took hold of him, entering the house as he did so, and informing him that he was being arrested for refusing to supply a sample of breath. After a struggle in the hallway, the defendant was taken to the police station and charged with failing to supply a specimen of breath. The charge was originally dismissed on the ground that the particular section involved gave the arresting constable no authority to enter the defendant's home as a trespasser in order to arrest him. And then on dismissing the appeal, the appellate court said that the conferment by statute of a power to arrest without warrant in given circumstances did not carry with it any power to enter private premises without the consent of the occupier. And then, as a commentary to that case, the editor of the Criminal Law Reports went on to point out how ridiculous it would be for the officer, if he were not permitted to enter the home, to make the demand, to stand outside and shout at the top of his voice to the defendant within, "I require you to provide me with a specimen of breath from the street outside," and convicting him of refusing to do so if he didn't comply with that request. But I believe under the authority of the Eccles and Borge case, if in the circumstances, factual situation of that kind, the officer had the authority to arrest the accused on a charge of impaired driving or whatever, surely he would have the right to enter the home against the wishes of the defendant or of his wife to effect the arrest. Before I terminate my discussion, you might be interested in the decision in Regina versus Hoole of His Honor Judge Ord, because there is no jurisdiction in a provincial court judge, family division, to direct the police to serve and to enforce an order granting exclusive possession of a matrimonial home to a spouse, the police were not acting in the lawful execution of their duty in entering the accused's home, notwithstanding that the order was apparently valid on its face. But then there is a decision of Mr. Justice Carruthers. In the exercise of the court's inherent and statutory jurisdiction to oversee the welfare of children and to supervise and control the relationship between parents and children, the court and its judges possess the authority to enforce compliance with their orders by specifically enlisting the aid and assistance of peace officers, and accordingly, once the order was specifically brought to an individual officer's attention, either by personal service on the individual or on a superior or other person involved in the administration of the force, such officers were obliged to carry out those provisions, and anyone who declined or refused to do so is guilty of contempt. From this, it should follow that anyone who willfully obstructs such an officer in the enforcement of such an order may be guilty of obstruction. And finally, under the Family Law Reform Act, a spouse is equally entitled to any right of possession of the other spouse in a matrimonial home, which ceases upon the spouse ceasing to be a spouse. If the police are called, and in such cases usually by the wife, on a telephone complaint to them by the wife, during the course of or following a domestic dispute, may the husband lawfully use force to refuse them admission, or may he eject them from the home should they refuse to leave upon being requested to do so. And if he does, may he be convicted of obstruction or of assaulting the police in the lawful execution of his duty. There's a case in England again, a very recent one, in Regina versus Thornley, where the court and the commentary to it deal with that situation, and at the end of the commentary, the editor makes reference to the special nature of the wife's occupancy under the Matrimonial Homes Act, which could be used to justify an argument that she could grant such a license to the police officer to enter the home, a license which her spouse could not revoke. And that if the police officers entered the premises on her invitation, he could not revoke it, they would not be trespassers, and the husband would not be justified in using force to eject them. I believe my time is up.